My name is Mark Tarbox, and I'm a proud graduate of the Tenant Empowerment Program and a law clerk at EDN. I look forward to becoming an apprentice at EDN so that I can get my license to practice law.
Hello, my name is Alma, and I am a type student and a proud Spanish interpreter volunteer.
Hello, my name is Elena Popp. I'm the Executive Director of the Eviction Defense Network, also known as EDN or EDN. You're here because you have,
A notice to vacate from the sheriff,
which came with a 2-page writ of execution. The writ of execution is given out or issued by the court after you lose your case.
Or you're here because you have a judgment against you, but you still don't have a notice to vacate from the sheriff.
Judgments can take different forms. This one is on a judicial counsel form, which is a form that's created by the court.
On the left is a judgment drafted by the landlord's attorney. On the right is one drafted by the judicial assistant, also known as the court clerk. The TEP program has a 99% success rate for tenants with active cases that follow instructions. EDN has less than a 10% success rate once a tenant has lost a case. We will only help you with a motion to change or set aside the judgment against you if your motion is very strong and if someone is available to write it. We also consider whether helping you will jeopardize the situations of TEP students that have a better chance of success than you do. To ask for an assessment of your case, watch videos 1A and 1B, pick up a copy of your case file from the court, and then text your PIP to 310-704-8785. The last line of your PIP will be, I lost my case on this date. I have a notice to vacate from the sheriff that expires on this date. If you don't know what a PIP is, you haven't watched videos 1A and 1B, please stop and watch them now.
Follow our instructions to get the best possible result in a bad situation.
The lockout can happen as early as the day after the date that is written in the middle of the notice to vacate. Unless the sheriff's department changes its policies without telling us, it will not happen on a Saturday, Sunday, Monday, or a court holiday. The sheriff is often behind schedule on executing lockouts. They usually do the lockout 3 or 4 days after the date indicated. We have seen them come out as late as 3 weeks after the date. The 111 North Hill Street Sheriff moves slower than others because the Stanley Moss Court has more eviction cases. Even though you could get more time, you should be prepared to vacate by 6 a.m. on the day after the vacate date on the notice.
111 North Hill Street Sheriff's Office sometimes sends their cases to other courts. Look here to see who is actually going to do the lockout.
We call this the vacate date. We do not call it the lockout date because it isn't the scheduled lockout date. The lockout is scheduled by mail with the landlord or with the landlord's attorney. Neither the landlord, the landlord's attorney, nor the sheriff is allowed to tell us the actual lockout date. Be ready by 6 a.m. on the day after the vacate date by following our packing instructions, but do not do a panic move out. You are likely to have more time than this. Don't do a panic move if we have agreed to help you settle the case. We lose leverage in the negotiation if you move out. So don't do a panic move if you want to petition the court to reverse the judgment. Don't do a panic move if you have no place to go other than your car or hotel. You should stay in your unit as long as possible. Wait for the sheriff to lock you out.
Hopefully this will help you breathe a little so that you can watch the rest of the video and follow our instructions. There is no guarantee we will have someone available to help you with your motion, but you increase your chances that we will make someone available if you follow the instructions.
This is the step-by-step on our website for notices to vacate from the sheriff. If you are watching this video, you have hopefully already watched the video on how to get help from EDN 1A. If not, stop and watch that video first. You should have already watched video 1B from Zoom to Victory video. If not, stop and watch the video. You should have already filled out an EDN intake application. If not, stop and do it. The link to the EDN intake is on the bottom of the homepage of EDN website. By now, you should have already gone to the court to pick up all the papers listed. If not, listen to the rest of the video and then go do it. Make sure you have all the papers on the list. In most courts, there is one clerk's office. You should get the complete case file and the registry of actions in the clerk's office. In the downtown court, which is also known as the Stanley Moss Court, you get the case file and the registry of actions in room 112. You file papers in room 102.
This is the proof of service of the summons and complaint.
The name of the form is in the bottom center. This is true of all court forms. When we ask you to look for a form, carefully search the bottom center of all documents for the specific form we're looking for.
The number of pages and the page that you are on is on the lower right. When we ask you to send us a form, send it as a PDF unless specifically instructed to text a picture. Make sure you send all the pages of each form by checking the lower right corner to see how many pages the form is. You can get a free PDF scanning application that allows you to take pictures with your smartphone and turn it into a PDF. You can also scan documents at any public library.
Look here to see who they say they gave the summons papers to. Sometimes this has a name. Sometimes it has a description. Is the name yours? Is it someone else that is being sued? Does the description match someone in your household?
This is the date and time that the process server or the person that supposedly gave the summons and complaint is saying they handed the summons and complaint papers to you or to someone else in your household.
Where exactly was the person who supposedly received the summons papers on the specified date and time? Do you have witnesses and other ways to prove the identified person was not home when the summons was supposedly given to them? Some ways to prove the identified person wasn't home to receive the papers include data on a cell phone, receipts with a timestamp that show the identified person was somewhere else, photographs on a smartphone that clearly show the person was somewhere else, boarding passes, airline tickets, and passport stamps, declarations of witnesses.
We need the entire case file, including the case summary, which is also called the registry of actions.
After you pick up the file, text your updated PIP to 310-704-8785. The last line of your PIP will be, I lost my case on, you will put the date. I have a notice to vacate from the sheriff that expires on this date. You will enter the date. I have my complete case file, including the proof of service of the summons and complaint and the registry of actions. I have followed the first 4 steps on the website. If you don't know what a PIP is, you have not watched From Zoom to Victory. Please stop and watch the video now.
We're going to explain to you what to do, but you must listen carefully and you must pay attention and you must take notes. But first, a little bit about EDN. The Eviction Defense Network, also known as EDN or EDN, is a nonprofit legal services program in Los Angeles County that's been at the forefront of stopping displacement and gentrification since 2003. Follow the instructions in this video and participate regularly in our webinars and in our empowerment classes. Watching the video alone does not replace legal advice or an assessment of your case by a lawyer. Remember that the laws change and the most up-to-date information can be found on our website and at our Tenant Empowerment Program events.
The Eviction Defense Network is a proud member of the LA County Right to Counsel Coalition and its Stay Housed LA program. Please go on stayhousedla.org and click on Get Help, Get Legal Help, fill out the application for help. Be ready to tell us the agency you are assigned.
If you have a disability, including a learning disability, and need a reasonable accommodation, please let us know.
We cannot have social justice without language justice. Please help us by being patient with the interpretation. Unless we are interpreting, simultaneously speak one sentence at a time. Wait for the interpretation.
We know you're stressed. Overcome your stress through knowledge and power. Watch the videos. Come to the webinars to learn the law. Come to our empowerment classes to learn the procedure and how to be a winner. Come to the tenant support group to get moral support and to be around tenants that have gone through the eviction process and were victorious. People with notices to vacate from the sheriff are much harder to calm down. As a result of your anxiety, people with notices to vacate often make mistakes that cost them their homes. You can avoid making mistakes by listening carefully, taking notes, and following instructions exactly as they are given. Recently, a client was not available at the time that we asked her to be available to finish her paperwork. She missed her filing deadline and was locked out. This could have been avoided. Another client missed one signature on a form and her application to stop the sheriff was denied. She had to take a bad deal, a bad settlement, to avoid the risk of being locked out the next day. Another client texted without a PIP, and we did not realize that they had received a notice to vacate. This delayed us getting to court on an expired notice to vacate from the sheriff. Again, this could and should have been avoided. These are dangerous mistakes that will cost you your home.
This document is called Handout 4, and it explains in detail what you should expect after you've lost your case. You can get Handout 4 at any tech class or by going to the EDN office located at 205 South Broadway, Suite 280, Los Angeles 90012. Read it, understand it, ask questions if you don't understand something. Sign where indicated.
First, it's important for you to understand we only have success 10% of the time in getting a motion to set aside judgment granted. You must be prepared to lose or to settle. Depending on the situation, depending on the facts, depending on what actually happened, rather than do a motion, you may want to settle. If you want to stay and you have all the rent you owe, not just what is demanded in the notice, but all the rent you owe, you can offer the money and ask if they will let you stay. You are in a weak position because you have already lost. You may also need to offer attorney's fees and costs. To understand the landlord's mentality, you must think like a business person, someone that wants to maximize their profits. The landlord is not likely to accept your pay and stay offer if they can raise the rent to market. If they reject the pay and stay offer, you may need to make a move out offer. You may need to agree to move out in as little as a week, especially if they agree to keep your record sealed. By keeping your record sealed, no one will know about the eviction. We will also try to get the other side to agree that there will be no money judgment against you in this case. Unless your facts are strong, it will not be possible to get them to agree to forgive the rent. They will want to preserve the right to sue you for all the back rent later. To really understand this slide and this process, you need to watch videos 1A, 1B, 2A, 2B, 2C, 2E, and 2H. Those videos give you the background you need to decide how strong your case is and whether you should be making an agreement to move out or whether you should be fighting to get back into court, even though it's a long shot.
If you don't have a notice to vacate from the sheriff, you can get an approximate idea of how soon you will get the notice to vacate by checking the Registry of Actions.
This is a sample registry of actions. This one was printed in room 112 of the Moss Court. Because the record is sealed, it can't be printed online. All eviction actions are sealed when they are filed. Sealed means no one knows about them except the parties and their lawyers. Your rental record is protected so that you can find new housing. The record will stay sealed unless you lose in the first 60 days after the eviction is filed. The record will stay sealed if you win your case, the case is dismissed, or you settle your case with a request that the record remain sealed.
This sample registry of actions was printed from an attorney court portal. We have been told that tenants representing themselves can get the registry of actions online, but some of our tenant empowerment program students reported that they have only been able to print the registry of actions from the computers at the courthouse.
The registry of actions may also look like this. This is a case summary on a random record that is already public. Regardless of which of these three versions you have, you're looking for the words writ of execution. Writ of execution.
This is the writ of execution. After you lose the case, the court issues the writ of execution. The sheriff cannot lock you out until after the writ of execution is issued. In fact, the sheriff does not even know that you have lost your case until the writ of execution is delivered to them. Once the writ of execution is issued, the plaintiff takes it to the sheriff. Go to the court and ask for a printout of your registry of actions. Does your registry of actions show that a writ has issued? Once the writ of execution is issued, you can check the status of your case on the sheriff's website.
If you don't have a notice to vacate yet, you don't have exigency. This means that you are not in a crisis or emergency yet. Losing your case feels like a crisis, it feels like an emergency, but the court does not see it that way. So you have to keep checking the sheriff's website daily at lasd.org.
Click on Court Services.
Click on Service of Civil Process.
Click on Case Inquiry.
Insert your case number and the last name of anyone named in the defendant caption of the complaint.
This means that the sheriff does not yet have the writ of execution. Once the sheriff receives the writ of execution, the case will appear here. The sheriff will process the writ of execution in about 3 or 4 days. A notice to vacate will be prepared, and it will be given to the officers that serve the notices to vacate. It will take 3 to 4 days for the notice to be delivered to you. If you are home, they will hand it to you. If you are not home, they will post it on the door and also mail you a copy.
As we explained earlier, the sheriff does not come out Saturdays, Sundays, Mondays, or court holidays, and the sheriff is often behind schedule.
It's important for you to note that we may not have someone available to help you write the motion to set aside judgment in your case. Even if we do find someone to write the motion, you still have to get ready for the lockout. The sheriff will only give you 5 to 15 minutes to get out of the unit, and we have less than 10% success in winning these motions.
Unless you get an order from the judge to stop the lockout, you will have 15 days after the lockout to get any belongings you left in your unit. You will have 1 4-hour period in those 15 days to get your remaining belongings out of the unit. The landlord can keep or throw away any of your things unless you pay a reasonable storage fee for the time after the sheriff locks you out. Your monthly rent divided by 30, which is called the daily rental value, is considered a reasonable storage fee, but they can charge you whatever they want.
We recommend that you stay in the unit as long as possible, unless you have a place to go other than a car or hotel.
To get prepared, start by getting 2 colors of garbage bags, boxes, and tape.
Sort your property into 5 categories.
Category 1, items you will throw away. Category 2, items you will recycle.
Category 3, items you will give away. Category 4, items you will sell. Consider having a garage sale or use the time to sell your stuff online.
Category 5, items that you will keep.
Pack a suitcase with 2 weeks of clothing and toiletries.
Gather all your important documents.
Gather and pack your photographs, your journals, items of sentimental value, other irreplaceables.
Gather and pack items of monetary value. Please don't keep large amounts of cash in your home. We hear all the time that people are locked out and the $5,000 of saved rent they had under the bed came up missing. Open a bank account or keep it in certified funds or money orders. If you choose certified funds or money orders, keep them on your person or in a safe place outside of the unit. If you choose money orders, watch our video on how to pay rent like a pro. There you will learn that it's important to keep the stubs or the carbons separate from the actual money order itself. Money orders must be filled out or they are just like cash. If you lose both the money order and the carbon or stub, you cannot get your money back. Consider bank cards, which you can buy at a market or get a safety deposit box. And if you left valuable items in the unit, don't expect the judge to believe you had them without photos and receipts. If you have valuables, pack them and take them out of the unit now before the sheriff locks you out.
Remember, you will have 15 days to get your things out. The owner can keep or dispose of your things unless you pay a storage fee for the days that your property is in the unit after the sheriff locks you out. If you decide to leave things behind for pickup within 15 days, take a photo of each layer of what is inside each box. Number the boxes. Keep track of what is in each box by taking a picture of the box and the number. Stack the boxes neatly in one place against one wall and take a picture of the number boxes and all other items you leave behind. If you sign a stipulation for judgment, make sure you did not give away these additional 15 days in the stipulation for judgment. And please remember that hotels and storage are a waste of money. Ask friends to store your things. Couch surf. Don't pay $800 per month to store things that are worth less than $5,000 or even $10,000.
Again, follow the packing instructions. Even if we're trying to save your home, stay in the unit as long as possible to avoid wasting money on hotels, but be prepared to take all your valuables, items of sentimental value, and 2 weeks of clothing and toiletries with you when the sheriff comes.
Protect your children from the traumatic experience of the sheriff showing up to lock you out by making sure they are not home when the sheriff arrives. Send them to live with relatives. Get them out of the house early each day and keep them away until 4 o'clock.
If you have pets, arrange for them to stay with friends. Boarding is expensive. Find another way.
Trust me, if your pets could talk, they will be telling you to listen to the very strict but nice, big-hearted lady lawyer. Find a friend or relative to take them in.
If your notice is expired, we require that you sign here on the handout 4. This explains that the first time you go to court with the paperwork we give you, you could be locked out while you're in court. You understand this, but you still want to try to stop the sheriff.
If the judge stops the sheriff, within a week or two, you will go back to court to explain to the judge why you should be given another chance to present your case. Use this time wisely. Prepare to lose that second court hearing because we usually do lose that second court hearing. Listen to us if we tell you that you have a low chance of winning, that you should settle and prepare to move. We recently had a notice to vacate case with a very credible tenant who had proof she was not home when the notice was served. She still lost. The process server said he served her the notice. The judge believed the process server over the data in the tenant's phone and the tenant's witnesses. We recently had a case with a woman who had proof she was at church at the time she was supposedly personally served. She had 10 witnesses. The judge still decided against her.
If you're willing to risk 1 month's rent, posting it to either the plaintiff's attorney or the court will improve your chances of the emergency application being granted and getting a hearing date.
Sign here to tell us you do understand. Do not sign if you don't understand. Ask for more explanation if you don't understand.
The first thing we need to do is figure out if we can win the motion. If yes, then you need to figure out if we can win the case itself. Is it worth trying? Are you willing to risk a month's rent to improve your chances? Do you want to invest the time that it takes to fight when you should be looking for new housing? At EDN, we also have to decide if it makes sense for us to spend scarce attorney and staff resources on a case that has less than 10% chance of winning.
We need to know how you got into this situation. Please mark any reason that applies. I did not answer the summons and complaint for eviction. I received the summons and complaint, but I wasn't named in the complaint, so I didn't do anything about it. I filed an answer, but did not pay the filing fee after being ordered by the court to pay. I filed an answer, but did not appear at my trial date. I went to the trial and signed an agreement to move. I lost at trial.
Tell us how you found us. Was it the Shriver Project, which is located in room 115 of the Stanley Moss Courthouse? Was it a self-help center at any other courthouse? Was it stayhousedela.org, or was it some other agency?
If the reason you are here is that you did not respond to a summons and complaint from the court, please
fill out this section of the handout for form.
Were you served the summons and complaint? Respond either yes or no.
If no, we need the proof of service from the court. It's in the case file. That way we can see who the processor claims they gave the papers to. Then we need proof that that person that was supposedly given the papers was not at home on that date at that time.
Our clients are usually in disbelief that they can be evicted even though they did not get their day in court. In 98% of the cases, a licensed person who has no skin in the game and whose only job is to deliver court papers swears under penalty of perjury that they delivered the papers according to the law. In 90% of the cases, the judges believe the word of the process server over the word of the tenant, even when the tenant has evidence that they were somewhere else.
If you answer that you were served, you did get the summons and complaint, then you have to prove that your failure to answer was due to mistake, inadvertence, or excusable neglect. And this is harder to prove than it sounds.
We need to know if any of the following apply. The reason has to be very compelling.
I didn't receive the summons and complaint personally, so I thought I did not have to answer.
I received the summons and complaint after the deadline.
I did not understand what to do.
I don't read English nor Spanish.
My education is limited. I reached grade level, and tell us what grade level you reached.
I have a learning disability.
I'm on medication and the medication impaired or made it too difficult for me to understand.
I was in the hospital.
I tried to get help but couldn't find anyone. You will need details of all the calls you made and start figuring it out by reviewing your call history on your phone.
I was told I did not have to answer. Who told you? What agency and when?
Did you have a different reason for not filing an answer? Explain it on the back of the form.
You also must explain any delay coming to the court after you found out about the lawsuit. People often come to us months after they found out they are being sued. The judges are not tolerant of these delays and excuses, and we are losing many of these petitions.
You must also explain why you ignored this notice from the court. This is a warning letter from the court. The court mails at least 2 copies. It's hard to argue you didn't get it. 90% of the time when tenants tell us that they did not get this notice, we find it in their papers, often still sealed. So open your mail, read it, bring it to TEP class, watch all the videos in the video series.
You must explain why you ignored the request for entry of default.
This was sent to you by the opposing lawyer, and it looks like this.
Do you have problems getting your mail? What proof do you have? Explain on the back of the form.
Sometimes tenants find themselves in default, meaning they've lost because the court denied the fee waiver for their answer, and the tenant didn't take the steps to have that decision appealed or reconsidered, and they did not pay the fee by the deadline.
Fill out this section if your fee waiver 001 was denied and you did not pay the filing fee. If you were ordered to pay a filing fee and did not, what is your reasonable excuse for not paying that fee? What efforts did you make to get the money?
Sometimes you get a judgment against you because you did not receive the notice of trial.
Fill this out if you missed your trial date. If you did not go to your trial, then a judgment was filed against you. The trial was held in your absence. Go to the court and make sure the notice of trial was not returned to the court. Sometimes we find the return envelope in the court file. Do you have problems with the mail? Could the owner have taken it? Is your mailbox secure?
Tell us, I did not get the notice of trial because
I share a mailbox with my landlord.
I put the wrong address on the paperwork for the answer.
The lawyer put the wrong address on the paperwork.
If the reason you have a notice to vacate is that you signed an agreement to move, then please
Fill out this section of the handout 4H. Note that the courts are very strict about enforcing agreements to settle lawsuits. For example, a judge once refused to give us an extra 3 weeks for an 84-year-old woman who was hit by a car after she signed the agreement. She was released from the hospital 4 days before the lockout. The judge would not give us 3 more weeks to get her placed in an appropriate facility. If you sign a payment plan agreement and you are even 1 minute late on a payment, you will likely lose your home.
once you sign an agreement, you have very little hope of getting out of it.
We teach in the TEP class that you are all warriors and superheroes. Meet your kryptonite. The stipulation for judgment. Once you sign the stipulation, it's not about how good your underlying case is, or how evil your landlord has been to you, or how unfair your situation is. Once you sign, you have signed, and you have waived or given up those arguments, at least in this case. You probably still have the right to sue the other side, but this case is over. This is why we have a movement for a statutory right to counsel, the right to an attorney by law, Tenants need lawyers to help them through the eviction process and avoid bad agreements to move out.
Now, there are some exceptions. Sometimes the court will change their mind. One of those exceptions is fraud by the opposing attorney. Try that again, sorry. Now, there are some exceptions. There are times when the court will reverse an agreement. Fraud by the opposing attorney or by the landlord is one of those exceptions. Did the opposing attorney or landlord mislead you or lie to you?
We were able to set aside the case of a tenant with a 100% winnable case that was misled by both the judge and the opposing attorney into believing that the opposing attorney was his public defender. We were able to set aside the case of a tenant with a 100% winnable case in which the judge inappropriately gave his legal opinion of the case and misled the tenant into believing that the tenant was going to lose. Fortunately, in this case, the judge was big enough to admit he had done that.
Mental incapacity is not enough of an excuse unless we can prove that you are also so disabled that you lack any capacity to understand or sign a contract, not just this stipulation or contract, but any contract. We must prove that you are so disabled you need a guardian ad litem or a conservator. We were able to set aside the case of a 94-year-old with dementia who clearly did not have the capacity to sign, and the owner knew it. We got her a guardian ad litem to make her decisions. However, we lost the case of a woman whose doctor said that she had diminished capacity, but was capable of living on her own.
Theoretically, being on medication when you signed could work, but you would have to explain how you got. Theoretically, being on medication when you signed could work, but you would have to explain how you got to go to court. Theoretically, being on medication when you signed could work, but you would have to explain how you got to court. You would need to establish that you were notably unable to think or process information due to the medication.
Help us determine if there's any chance to set aside the stipulation. Are you elderly? Answer yes or no. What is your age?
Do you have diminished mental capacity? Answer yes or no.
Do you have a mental health professional? Answer yes or no.
Do you have a very low formal educational level?
Do you have English language capacity issues?
Is there any other disability that should have been accommodated? For example, an ALS interpreter was requested but not provided.
We often hear from tenants that they were forced to sign under duress. We often hear from tenants that the other lawyer bullied them into signing. Prepare for the bullying. Prepare for the pressure. Prepare by coming to TEP class, by going to the support group, by watching video 2H, which is the one on what to expect the first day in court, because these arguments do not work. Age, disability, language, and educational limitations could support an argument that the other side used duress, but the person has to be very frail, very elderly, severely diminished in their capacity. We recently lost a case, even though the doctor wrote a declaration that the tenant's educational and reading ability was no more than 7th grade. The doctor stated that the tenant had mental capacity issues, but that she could live independently, which she had been doing. We lost the case of a woman with a mental health diagnosis who was bullied by the plaintiff's attorney with threats of an immediate lockout if she did not sign. The lawyer denied the bullying. The judge believed the lawyer.
Generally, if you're going to argue that you were forced to sign an agreement, you should expect to be asked to describe the size of the knife held at your throat or the caliber of the gun that was pointed at your head.
My lawyer made me sign. If your lawyer made you sign an agreement to move out without properly explaining it to you, then you need to sue your lawyer. The judge will not set the stipulation aside because your lawyer misled you.
If you went to court and lost,
We will only be able to help you if we find that there is a technical defect in the paperwork. And again, we have to have staff available to actually do the paperwork. Fill out this part of the form.
If you lost your case, it's usually because the judge decided that you did not have a good defense, or that you did not have enough evidence, or that the other side was more credible. Asking that judge to reverse themselves is nearly impossible.
You ask the trial judge to reverse themselves by filing a Code of Civil Procedure 663 motion or a Code of Civil Procedure 657 motion. These motions are due 15 days from the date of the notice of entry of judgment. You can also file an appeal. An appeal is due 30 days from the date of notice of entry of judgment. If there is time to file a 663 or a 657 motion, and there is a possibility it will be granted, we recommend you do that before filing an appeal.
filing a motion or appeal will not stop the sheriff. The same trial judge must give you a stay of execution pending. This is an order stopping the sheriff from locking you out while you file the motion or appeal. These motions are usually denied. You can appeal the refusal to grant a stay of execution to a higher court, but higher courts rarely overturn the lower court.
If we have time, an attorney will look at your court file and tell you if they think there was an obvious error. If there is an error in the law, in which case we will recommend a motion under 663 or 657, and whether or not you have a basis to file an appeal.
You can file a claim of right to possession if your name is not on the summons and complaint, and they did not serve a pre-judgment claim of right to possession, and you have lived in the unit when the eviction case was filed, or this is a post-foreclosure action against the foreclosed owner.
Is your name in the caption of the complaint? If you are not listed in the caption, or if there is an adult occupant in the unit that was there when the eviction action was filed and is not on the caption,
Look at paragraph 24 of page 2 of the writ of execution. Is box 24A2 marked? This paragraph says that they did not serve a paper called a claim of right to possession when they served the summons and complaint. Any adult that was living in the unit when the summons and complaint was filed and is not listed on the caption can stop the sheriff by filing a pre-judgment claim of right to possession. This will stop the sheriff. It also brings that person into the case, so they should make sure that they can win.
if you're not a named defendant, meaning your name is not in the caption, and you meet these two criteria, you need to decide whether to fill out this form. Again, the criteria to file this form are, number one, you were living there before the eviction complaint was filed, and you are still living there, or this is a post-foreclosure eviction and you are not the former owner. Only do this if you can prove you lived there before the complaint was filed and if you can win the case.
Put the name of the person making the claim. Enter the property address. Enter the phone number of the person making the claim.
Put the court information here.
Put the plaintiff's name here.
Put the name of the defendant as it appears on the summons and complaint here.
Put the case number here.
Make sure you qualify. Make sure you are not named in the complaint and you were living in the unit before the lawsuit was filed and you are still in the unit. Or This is a foreclosure eviction, post foreclosure eviction against your landlord. Note that you must have proof of your occupancy of the unit. These include the rental agreement, rent receipts that are in your name, utility bills in your name, mail addressed to your name at the premises, driver's license with the address of the premises, and you must have strong enough evidence of the underlying case to win. Otherwise, you risk an eviction on your record and you risk owing the owner all of the back rent that is right now being charged to that master tenant or the person that was sued.
If you are going forward with this action, put your name here.
Your address goes here, and it needs to be the address of the premises. Please don't lie to help a friend. It is fraud against the court and very risky.
The address of the premises.
If this is a post foreclosure eviction, check here.
Put the date the lawsuit was filed here.
Swear under penalty of perjury how long you have been living at this unit.
Swear under penalty of perjury that you were at least 18 years old when the complaint was filed.
Swear under penalty of perjury that you lived in the unit when the complaint was filed and you still live there.
Verify that you are not named on the complaint.
Verify that you understand that you must prove your claim of possession at a court hearing. This means you must bring the proof that you're on the lease. You must bring the receipts, the utility bills, the mail that's addressed to you at that address, your driver's license with that address, etc.
Verify that you have to pay a filing fee or file a fee waiver to get a hearing.
You will get a very quick hearing in a week or so. You can get a longer hearing date if you post 15 days worth of rent with the court.
You can present your claim in court or to the sheriff. We suggest you do both. If you have time, present it in court and have extra copies to give to the sheriff if they come.
The clerk will fill in the hearing date here.
Here, you have to say the basis for your claim. Did you have an oral rental agreement with the landlord?
Or was it a written agreement with the landlord?
Did you have an oral agreement with someone other than the landlord?
Did you have a written agreement with someone other than the landlord?
Did you have an agreement with a foreclosed landlord?
Or was there some other agreement? And then explain what it is here.
This explains the requirements again.
In some circumstances, we can ask for a hardship motion to allow you to remain as a tenant even after you've lost. In order to qualify, the unit should be protected by a just cause ordinance or rent stabilization ordinance or have an unexpired lease. If it is not protected, the motion is likely to be denied because they can force you out anyway. You must prove that your hardship that is greater than that of the owners. Tenants have a better chance of being granted a hardship motion if one or more of the occupants is disabled or elderly, or if it's a very large family.
Fill out this section of the form if you think you qualify. Tell us if you are disabled or have a disabled child. If you are elderly, what is the age? Are you very poor? What is the monthly income? Do you have a large family? What is the size? Do you have very low rent? What is the amount? Is the unit rent controlled? Is it a subsidized unit? Have you had a long tenancy? What is the number of years? Is it a subsidized unit? Have you had a long tenancy? What is the number of years? Other special circumstances, describe them here. Do you have all the rent? Do you have money to pay the landlord's attorney fees? Explain why the eviction is not your fault. If there is time, a lawyer will look at your paperwork and circumstances and tell you if this is worth proceeding.
From the moment that you made contact with us, we instructed you to keep a journal and to start a housing search. That detailed journal and housing search will be used to prove that displacing you is a bigger hardship than the landlord's hardship for keeping you, because you have no place else to go and you can't find housing. You must be able to pay all the back rent. If you have not started keeping a journal or doing a housing search, start today.
There is also the possibility of getting a little bit more time. The maximum we can get is 40 days from the date the judgment was entered. We often can't do this motion because usually more than 40 days have already passed since the judgment was entered.
You need to give us as much detail as possible in filling out the form. We need to tell a story. You need to answer the questions and give us details on a separate piece of paper. This is additional basic information that we need to start the paperwork. Please tell us your move-in date, how many bedrooms there are in the unit. Is it rent controlled or rent stabilized? Yes or no. Is there a government subsidy? Yes or no. How much is your rent? How much are rents for comparable units in your area? The date the sheriff posted the notice to vacate and the date the notice to vacate expires.
If there is time to assess your case, we will give you the results of consultation in writing and you will receive it in a handout. We have offer representation, see separate retainer. As we have stated repeatedly, these motions are very hard to win. You must be prepared to move if we are not successful. Follow the packing instructions on page 1 of this handout.
If we decide to move forward, we will tell you the proof that you need to bring. It is listed right here on the handout.
Sometimes the kindest thing we can do is to tell you it's time to pack up and move on. Get 2 colors of garbage bags, plus boxes and tape.
Do this today and sort your property into the 5 categories.
Category 1, throw away.
Category 2, giveaway. Category 3, recycle.
Category 4, items to sell. Category 5, items to keep.
Pack a suitcase with 2 weeks of clothing and toiletries.
Pack your important documents.
Pack all your photographs, journals, items of sentimental value, and other irreplaceables.
Pack items of monetary value.
As you pack each box, take a photo of each layer of what is inside. Number the boxes. Keep track of each box by taking a picture of the box with the number. Stack them neatly in one place against one wall and take a picture of all the numbered boxes and all the other items you are leaving behind. You will have 15 days to get these items out. Keep in mind that we hear reports of theft all the time. You must be able to prove that you had something, that you had a particular item if something turns up missing. You will have 1 4-hour period in the 15 days after the sheriff locks you out to come back and get your things. If you signed a stipulation, make sure that you did not give away those additional 15 days in the stipulation. And please remember that hotels and storage are a waste of money. Ask your friends to store your things and ask your friends to take you in and ask your friends and family to take in your pets.
Follow the packing instructions even if we are trying to save your home. Stay as long as you can to avoid wasting money on hotels, but prepare to move out.
At this stage of the lawsuit, the best results may not make you happy.
In fact, they may make you sad and angry. We do have a 98% overall success rate in representing tenants. The Tenant Empowerment Program is having a 99% success rate so far, but we have less than a 10% success rate once you have lost your case. If time permits, we will assess your case. We will give you the best possible advice and make the best possible effort. And if we can't turn the judgment around, we will help you make a plan. and then you will need to move on with your life.
It's likely that your record is still sealed and that there is no money judgment on your record. To see if your case is sealed, Google Los Angeles Superior Court case summary and insert the case number.
Click on Case Summary Online Services.
Put in the case number.
Put in your court, even though it says optional. It's a drop-down menu. The downtown court is under S for Stanley Mosque.
If this is what comes up on the screen, it means your record is sealed.
We urge you not to max out credit cards or other funds on hotels. Call 211 and get shelter referrals. Couch surf. Sleep in your car.
If you use your limited funds on hotels, you will fall into this vortex of homelessness where you'll be housed part of the month and then on the streets part of the month.
Save the funds you have to pay the deposit on a new home.
Call 911 and get shelter referrals.
These are the next steps.
We are very overextended and you must follow these instructions.
Number one, if you are watching this video online, come to a TEP class. You will find the days, times, and links to the Tenant Empowerment Program Zoom events on our website, edn.la.
At the class, you will be put into a room to watch this video again while we counsel other tenants, or we may ask you to return for a special session just for notice to vacate clients.
We will then counsel people in priority order based on urgency.
If you have not already done so, sign up for legal help at stayhousela.org and be prepared to tell us who you were assigned.
Follow up with that agency, but keep in mind that all agencies are at capacity.
Consider hiring a private attorney.
Do the best you can to prepare. Watch all the videos and gather all the evidence.
Pay special attention to what to expect my first day of court and the discussion about judges and commissioners.
Do the best you can to prepare by using handout 4 to figure out how to tell your story in detail.
Write a paragraph that tells your story in detail using this example, which you can get at a TEP class from the shared drive. Ask for it.
Here is the sample. You can request it at any of our TEP classes.
Go to the Schreiber Project at room 115 of the Mosque Court, or go to a self-help center to see if they can draft your ex parte application and motion.
When we tell you it's your turn, be prepared 24/7 to work with us.
If we say we're calling you at 4 a.m., set an alarm and be ready to answer questions sent by text. Be ready to meet on Zoom or to talk to us on the phone.
When we say to give notice to the other side, use the template we text you to give the notice. It must be done between 9 a.m. and 10 a.m. on the day before we go to court.
Either the day before or the morning you are going to court, we will email you the documents for printing. Let us know in advance if you have a printer.
You must file by 8 a.m. on the day you are going to court.
Depending on the court, the hearings are at 8:30 a.m. in Compton, 11 a.m. in West Covina, or 1:30 at Mosque and Pasadena courts.
For other courts, call the court to find out when ex parte applications are heard in your court.
Be attentive to further instructions.
Join us on Mondays and Wednesdays at 5:30 p.m. and Saturdays at 8:30 a.m.
Remember that our community is like a ship in a storm. We're taking on water and all our lawyers are in the water rescuing tenants.
We can only give a lawyer to 10% of the people who need lawyers. That means 9 out of 10 people will need to learn to swim.
Help us bail water by educating yourselves. These empowerment classes and webinars will give you the knowledge and skills that you need to survive court appearances and stay in your home until a lawyer frees up or until you are strong enough to represent yourself.
We are available to you 6 days a week.
Help us be efficient at the empowerment classes and webinars by watching the How to Get Legal Help on the front page of our website.
Learn about webinar etiquette and how to use Zoom in a TEP meeting by watching our video from Zoom to Victory regularly.
When you join a TEP class, please mute yourself and stay muted until called upon to speak.
Learn how to properly rename yourself and protect your identity.
Know how to create and update your personal information paragraph and be ready to post your PIP privately in the chat when asked to do so and not before.
We are fighting for a better tomorrow.
A future where there will be enough lawyers for everyone.
Join our movement. Join your tenants union and ACE.
In the meantime, we're recruiting tenants that have gone through the eviction process successfully and are willing to help others. We're also recruiting organizers, teachers, the faith community, labor unions, and the staff of social and other service organizations.
The EDN office is overloaded. Please follow instructions and help us operate efficiently so we can assist as many tenants as possible. After completing the EDN intake, remember to always use your main email string. Reply all when you communicate with us. And if we don't get back to you, you need to come to the next tenant empowerment class or webinar.
If you're confused or need emotional or moral support, please participate in the Friday Tenant Support Group meeting. You can find the link for the support group on our website.
You are here in the video series. It is our hope that we will be able to reset your case so that you'll be back answering the complaint with a new answer and getting ready to win a trial. At that point, we want you to rewatch the video series again from the beginning. We find that we are less successful with tenants who didn't start at the beginning of the training series. Right now, you have a lot to do, and we are going to give you a checklist for all of it. That checklist will include going back to video 2A and getting caught up.
Be a winner. Attend our empowerment classes and webinars regularly. Together, we can all be winners.
Arrive to the empowerment classes on time.
Remember to mute yourself and rename yourself properly as soon as you join each webinar.
Watch our videos over and over and take notes. It takes multiple viewings to absorb all the information.
Come prepared with your current PIP ready to post privately in the chat when asked to do so and not before.
Come prepared with your trial notebook and exhibit notebook. The trial notebook has your court papers. Your exhibit notebook has your evidence. Watch the videos 2E and 2F on how to put these binders together.
Memorize your case number. Memorize your landlord's name and the name of the landlord's attorney. Know your case number and your department number. We cannot afford to waste time while you shuffle through papers to find this information.
Listen carefully when we are answering questions from other tenants. You never know when another tenant will ask the question you are going to ask. And if they do, please don't ask the same question. You also never know when another tenant will ask something you wish you had thought to ask.
Be respectful of the attorneys, staff, volunteers, and other tenants. Don't interrupt. And when someone else is speaking, and please speak slowly and one sentence at a time. Pause where there is a comma for interpretation.
Practice your late night FM DJ voice. Deep, calm, and confident.
Practice your poker face.
And memorize the ship in a storm speech, because together we can all be winners.
We look forward to meeting you at our empowerment classes and webinars.
Now that you have watched video 1A and 1B, picked up the file, filled out a request for services from EDN on the legal server as requested and applied to State House delay, please send your PIP to 310-704-8785. The last line of your PIP will be, I lost my case on, I have a notice to vacate from the sheriff that expires on, I have my complete court file, including the proof of service of the summons and complaint and the registry of actions. I have followed the first 4 steps on the website. If you don't know what a PIP is, you have not watched From Zoom to Victory. Please stop and watch it now.